Our last webinar focused on the obligations of the banks in particular under letters of credit and under the applicable rules of UCP. But this time we're going a little bit deeper into something that's really, really important. It's important to get it right, because if you actually get it wrong, the consequences can be very, very serious. So we're talking about the notice of refusal.
Okay, notice of refusal.
Yeah. Okay. So when we look at refusal of documents, we want to look at what bankers and beneficiaries really need to know. So what we're looking at here is the refusal of documents by a conferring bank, an issuing bank, but we'll also make reference to a nominated bank. Just 10 days ago, I did a series of seminars in India, in Delhi, Chennai, and Mumbai, and the notice of refusal issue was something that came up again and again in questions. So hopefully this webinar will be timely. So when we look at UCP 600 and we're talking about examining and refusing documents, well then our focus area is here. Documents are presented to a nominated bank, confirming bank, or an issuing bank. When the documents are examined, they're examined subject to article number 14 of UCP, rule number 14, standard for examination of documents. And
just 1 second, Vin. We have one or two echo issues from some participants.
Okay.
So I'm just checking to see if the echo is gone now. Okay.
Okay. I'll keep talking just so you can test it and you can get a little bit of feedback.
Okay.
From
Just
participants.
give it a couple of seconds. Just 1 moment. Yeah. Now it looks like we are better now, Vin. You can continue.
We're better now.
Actually, can you just start from the first screen again?
Yes, of course I
That's
can.
right. Yeah,
okay.
Great stuff.
As I mentioned at the seminars in India 10 days ago, there was a lot of interest in the notice of refusal procedure for banks, but we had a lot of questions from beneficiaries, which was actually interesting. So when we talk about the refusal of documents, of course, our focus area, first of all, is on the presentation of documents to a bank. When the documents are presented to a bank, they'll be examined by the bank, issuing bank, confirming bank, or nominated bank, the bank with which the credit is available. The standard for examination of documents covered in our earlier seminar is covered under Article 14 of UCP. But today, actually, we're looking at something slightly different. So, for example, we're aware that if the documents are complying, well, then a complying presentation is actually dealt with under Article 15, which basically says complying presentation, the issuing bank must pay or reimburse, confirming bank must pay or reimburse and forward documents to the issuing bank, nominated bank, if it pays, well then it must forward the documents to the issuing bank for reimbursement. But that's not really our focus area. Our focus area here is regarding examining, documents do not comply, discrepant documents, and refusing documents, discrepant documents, waiver, and notice, which is articulated in Article 16 of UCP 600. So this indeed is our focus area. Discrepant documents, waiver, and notice, Article 16. So let's get into a little bit of detail here in sub-article 16, A and B. So for example, when the nominated bank, which has acted on its nomination, the confirming bank, if any, if the letter of credit was confirmed, and an issuing bank determines that a presentation does not comply. So basically, they have checked, they've done their examination, they have come up with their determination that the presentation does not comply. Well, then, of course, the bank may refuse to honor or negotiate, for example, if the credit was available by negotiation. So the key thing is it may refuse. So let's look at a general explanation and what happens here. When we think of refusing documents, in most instances, people are thinking about the issuing bank. So let's focus on the issuing bank just for a moment. When the issuing bank that receives a presentation determines that a presentation does not comply, it may, in its sole judgment, approach the applicant for a waiver of the discrepancies. And this is actually interesting because we need to understand what is exactly meant by in its sole judgment. So, for example, when the issuing bank examines the presentation and if it does not comply, it may immediately refuse the documents. It does not need to necessarily contact the applicant. It does not need to make this judgment of approaching the applicant for a waiver, but it may, and to be quite frank, in most instances, it does. It may, in its sole judgment, approach the applicant for a waiver of the discrepancies. Now, again, under the rule, it's very important to understand that this process of contacting the applicant for a waiver does not extend the period of time for examining the documents, maximum 5 banking days. And this is articulated in the rule, as you can see it in front of you. This does not, however, extend the period mentioned in sub-article 14b. Sub-article 14, article 14, standard for examination of documents. So getting a little bit deeper into the process. Sole judgment, as we indicated, is not obligatory. Why? Because, as we've articulated, the issuing bank, on determining documents do not comply, may, in its own position, refuse the documents stating the discrepancies. Very often in letters of credit, there is something that, while not actually defined in UCP, is known as, let's say, a pre-waiver process. So this time, let's focus on the other side at the nominated bank, for example. So we've the beneficiary bottom left-hand side of your screen presenting documents to a nominated confirming bank. The bank checks the documents and say, for instance, they find 1 or 2 discrepancies. Well, the not nominated bank may actually send a SWIFT message to the issuing bank requesting a waiver of that particular identified discrepancy. Typically, what will happen on receipt of this message, now, of course, the issuing bank could refuse the documents, but typically it will also contact the applicant, informing them of the identified discrepancy and request a waiver. Assuming the applicant waives that discrepancy, the issuing bank will, of course, then send a SWIFT message to the nominated confirming bank, who then may proceed in safety with actually honoring the letter of credit or negotiation if it was available by negotiation. But it's very important to highlight that that waiver is only in respect of the actual discrepancies identified in their request by the nominated or confirming bank, and then actually the waiver approved and the message sent by the issuing bank.
Okay, Vin, can you just give us one quick moment and let's see if everyone is receiving us okay? Is everyone receiving us? Just give a quick yes in your chat box, please. Let's see now. Just give you a chance to rest as well, Vin. You're delivering a lot of information there.
Sure, Tom. No problem at all. Yeah, looking good.
Getting there. We have a slight lag on the transmission, but we will be getting information now from people.
Yeah, I'm getting 1 or 2 questions coming in on my Skype while you're testing there,
yeah,
Tom.
Actually, now it's starting to get some people.
Yeah. Okay.
Okay, it's looking good. Yeah, perfect. Everyone's fine.
Okay.
Great stuff. Let's keep going.
Okay, so let's now look at the procedure for the refusal. And this is really the core part of this presentation, the important part. But to illustrate the importance of this part, I will be referring to a quite famous court case just after I've gone through the procedure. So the procedure for refusing. Okay. So, for example, if an issuing bank has a relationship management application with the nominated bank, basically, this is an evolution from the BKE, SWIFT BKE, you could say, with a nominated bank. Well, then, of course, the formal message is the MT734, which is designated as the advice of refusal. It actually states on the message that it's an advice of refusal. So when refusing, and we have the SWIFT authentication with the nominated bank, or the RMA as it's now called, MT734 advice of refusal. Okay, if there's no SWIFT authentication RMA with the nominated bank, well then, of course, it's going to be an unauthenticated message, an MT999, unauthenticated message. And if there is no SWIFT address, which is not so common these days, okay, well then actually it has to be a manual notice of refusal. manual notice of refusal. So let's look at the notice of refusal, okay? And here is just a simplified example, but when we look at this, we see the three key important components. First of all, there's a statement or declaration of refusal of the documents. Now, as I said on the M34, it already says advice of refusal, but when refusing documents, it must be a clear statement of refusal, statement or declaration of refusal. Second, of course, under the rules, we must state each discrepancy in respect of which the bank is refusing the documents. And as we covered before, there must be a single notice, and a single notice must state each discrepancy in respect of which the bank is refusing the documents. And then you actually see field 77B here. In the notice of refusal, there will be information regarding the disposal or the disposition of the documents. Statement in the single notice, each discrepancy, status of the documents or status of disposal of the documents. Now, within the SWIFT messaging, there are other words or keywords that actually the issuing bank may use, such as hold, meaning holding, which is previous instructions, and very, very importantly, if they are refusing, the bank may return at its sole discretion, return the documents. Moving on just a little bit.
Okay, just one question though, Vin, if you don't mind.
Yeah.
Let me say now, just one question, Vin, if you don't mind. We have a question from Valentina in Kazakhstan.
Yeah.
She is asking, can you explain in simple terms the SWIFT keywords for the disposition of documents in notice of refusal? So what SWIFT keywords exactly?
Well, I just mentioned them a minute ago, and it's a good question, but I hope my memory is good enough, Valentina, to answer this question, but let me try, okay? As we mentioned, the keywords will be, for example, notify, or hold, or pre-INST, PREVINST, and then, of course, the dramatic one, return, but it actually happens. So let me explain. For example, the issuing bank issues the notice of refusal, and the key word used is hold. Well, that means that the issuing bank is holding the documents at the disposal of the presenter, waiting further instructions for the disposal of the documents. That one is pretty easy. The one you see on your screen, notified, is a little bit complicated, and that was due to one or two cases before the revision of UCP 600 was issued, but let me explain. When we use the word keyword notify, it means the issuing bank is saying that the documents are being held by the issuing bank until the issuing bank receives the waiver from the applicant. That is the waiver of the discrepancies, and most importantly, the issuing bank agrees to accept it. And there is an alternative, or the issuing bank receives further instructions from the presenter prior to agreeing to accept the waiver. Okay? The next one, PREVINST, previous instructions. This means that the issuing bank is acting in accordance with instructions previously received from the presenter, and this typically, these instructions would have been in the covering letter from the presenting bank for the documents to the issuing bank. And as we mentioned, the dramatic one, but it actually features in our court case in a few minutes, is return. And that means that documents have been deemed discrepant, the notice of refusal has been issued, a single notice stating each discrepancy, and the issuing bank is returning the documents. Quite dramatic, as we will see. Okay, I'll move forward, Thomas, if that's actually okay. Yep.
Just 1 second. Everything that you're saying, okay? We'll just give them a quick 10 seconds to confirm that we're receiving.
Sure,
okay?
Thomas. Yeah. Sure. We're getting there.
If anybody is having issues hearing the audio, if they refresh the page, they should be able to just refresh their connection, and that may help.
Okay, I'll proceed.
It seems we have one or two people with issues, but I think we can proceed. I think
Yeah.
most people are hearing us okay.
Actually, Thomas, maybe can you how many people have we on? Because I've no idea how big the audience is.
We've got about let me see, 124 right now at the moment.
124. Wow,
Yeah.
Great. Okay, let me proceed. Okay. Notice of refusal, no later than the close of the 5th banking day. Single notice stating each discrepancy in respect of which the bank is refusing. And then we've covered right now the status of the documents or the disposal of the documents, and we went through the SWIFT keywords. Okay, moving forward. How must this notice be sent? Well, the notice required must be given by telecommunications. And of course, we think of SWIFT, but it doesn't have to be SWIFT. Or if that is not possible, by other expeditious means, and again, no later than the close of the 5th banking day following the date of the presentation, sub-article 16D. And so must be given by telecommunications, and this is the medium for sending the message. So basically, if telecommunications is not possible, that means it must be sent by other expeditious means. But what does expeditious means? Expeditious means timely, effective, and without delay. And we're using the word expeditious by the close of the 5th banking day. So what can this comprise, this period of time? Well, from presentation, the examination of documents, if there was a pre-waiver procedure, any of that, and of course, the sending of the notice of refusal no later than the close of the 5th banking day following the day of presentation as articulated in sub-article 16B. Well, so what? So what? Well, so what? This is really important because if a confirming bank or an issuing bank in particular do not follow the prescribed procedure as set out in the rules, it can be a very dangerous situation because frankly, the documents may not comply. But if the documents do not comply and you do not issue your notice of refusal correctly, well then under the rules, the issuing bank will be precluded from claiming that the documents do not comply. Precluded means stopped, not allowed. Precluded from claiming that the documents do not comply. And if you can't say they don't comply, well, then they're deemed to comply and the bank must honor. So, as mentioned, we're going to look at a court case, which I will try to keep short and sweet to indicate the importance of strictly following the procedure when we deal with notice of refusal. Yes, Thomas?
Please go ahead.
And the case I'm just to introduce it before I take your question is Fortis versus Indian Overseas Bank, which focused pretty much exclusively on the notice of refusal, Article 16, and the procedure followed by a bank in this particular case. Thomas.
Okay, so we have actually one question from Natalia in Minsk in Belarus. And as a confirming bank, is it important when notifying the beneficiary of discrepancies to state we refuse?
Okay, actually, that is a really good question because many banks don't. Many banks state the discrepancies when they're talking to the beneficiary. And, you know, it could well be inferred that by telling them the documents are discrepant under a confirmed credit, well, obviously, the bank is refusing. But actually, it's not so obvious. So when we're into managing risk as a confirming bank, it is really important, as politely as you can, but make it clear in text and in the verbiage you use that the bank is actually refusing and state each discrepancy. And this is really, really, really important as we are going to actually see. So the answer is yes, it's important to actually state, because if you're refusing, you are refusing. If you don't refuse, you may be precluded. If you're precluded, you may have to pay. Okay, back to the case, Fortis versus Indian Overseas Bank. And this was, I think, the first UCP 600 case that came actually before the courts, as far as I'm aware. and the UCP 600. I will try to relate the case as best I can, but as short and concisely as I can as well. Here we have a situation where the issuing bank was IOB, Indian Overseas Bank. We had a bank that was in some letters of credit only nominated, but in another letters of credit in relation to the same case, also acting as a confirming bank. And the confirming bank's obligation, as we know, covered by Article 8 of UCP, additional undertaking of the confirming bank. And then, of course, the beneficiary you can see on your screen here. So here's the story. The issuing bank issued 5 letters of credit totaling 8,265,000 in favor of the beneficiary, going back to August 2008. And while not making any conclusion regarding it, August, September, October, November, December were interesting times, okay? Interesting times in the world of trade finance. In fact, interesting time in all financial markets. Here we have a summary of the letters of credit issued, and they're right there in front of you. And we can actually see on the first 3, they were confirmed by the confirming bank, Fortis, and in the other 2, Fortis was acting as a nominated bank. Now, what's really interesting and sometimes not observed correctly, that the issuing bank's obligation to a confirming bank and a nominated bank is really the same. The confirmation is just but very important, just an additional undertaking of the confirming bank to honor or negotiate. And UCP talks to the fact that the issuing bank must reimburse a nominated bank. But what happened? Let's see what actually happened. The beneficiary present documents under the first 3 letters of credit. Remember the first 3 letters of credit, and we actually saw they were confirmed, okay, and which the bank accepted, and the beneficiary was paid the amount due. And then, of course, as is normal, the documents are forwarded by Fortis to an issuing bank. So we have the bank acting as a nominated bank, confirming bank, but when sending the documents to the issuing bank is also a presenting bank. The documents presented under letters of credit were forwarded by the nominated bank to IOB. So far, so good. The bank, of course, rejected the documents due to what were, in the case, considered as valid discrepancies. And let's keep an eye on the dates. Valid discrepancies between the 4th and 19th of November 2008. So we had the issuance dates, and now we had the presenting dates. And we see here were considered valid discrepancies between 4th and 19th November 2008. You're still with me, I can see. That's great. So remember, notice of refusals must indicate the disposal or disposition of documents. Letters of credit, 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. 1, 2, return. We've explained what it means. The documents to be returned by the issuing bank. Hold, we've explained what that actually means. Documents held at your disposal. Letters of credit 4 and 5, return. Okay. But the documents were not returned. So issuing bank gave disposition of documents as required in notice of refusal, but no documents were returned. And then a subsequent action by the nominated bank, and in cases confirming bank, Fortis Bank, on January 2009. Remember the dates, November 2008, and now we have January 2009. Fortis Bank requested again return of the documents. But as it happened, without going into too much detail, the issuing bank did not return any of the documents until 16th of February 2009. Look at the dates. So what happened? Well, of course, the confirming bank would like to get its money. And when it would like to get its money, Stemcor and Fortis commenced proceedings in the commercial court against the issuing bank. So when we look at this, the proceedings were taken by Fortis on letters of credit 1 to 3, Stemcor letters of credit 4 to 5, okay? And what was the key issue to be resolved before the court? And as you know, if documents don't comply, an issuing bank does not have to pay. But of course, it must issue its notice of refusal in compliance with the rules, as I underlined in the first part of the presentation. And there are implications if a notice of refusal is not actually handled correctly. And this is very important for the beneficiary also to be aware. So the issue to be resolved before the court was whether the issuing bank should be precluded under Article 16F. F for sometimes fascinating, F for frightening, sometimes for an issuing bank, due to late return of documents. Did they follow the rule articulated in Article 16? Would preclusion apply? If preclusion applies to the issuing bank, they are stopped. They are not able to refuse the documents. They're precluded from claiming that the documents do not comply, stopped from claiming the documents do not comply, so they must pay. So then we look at the rule just to get a tight focus. If an issuing bank or confirming bank, wow, it looks like there's something missing when I read the rule. If an issuing bank or confirming bank, it kind of looks like the nominated bank is missing, but in fact, it's not missing. Remember when we covered Article 14 regarding examining documents, it talked about nominated bank, issuing bank, or confirming. But when we're talking about preclusion, the rule articulates only regarding the banks that have an obligation, an irrevocable obligation under the credit. So again, if an issuing bank or a confirming bank fails to act in accordance with the provisions of this article, Article 16, it shall be precluded, it shall be stopped, it shall be not allowed, it shall be precluded, stopped from claiming that the documents do not constitute a compliant presentation. So it means the documents are deemed compliant and the bank must pay or bank must honor. Okay? Okay. Now, so in the case, we have arguments from both sides. That's what makes these court cases so interesting. And while the arguments were substantive, I have focused on what I consider are the two key core arguments on each side. So, Fortis Stemcorp beneficiary nominated confirming bank. Well, here was the argument. And a very famous expert witness who you all know was actually on the side of Fortis and Stemcorp. So here we go. Key argument. Well, if the issuing bank gave notice, and it did, that it would return the documents, then on the proper understanding, construction of Article 16, the issuing bank, was under an obligation to return the documents promptly, which it did not. And if it failed to do so, then sub-Article 16F, the preclusion rule applied, which means the issuing bank must pay even if the documents are discrepant. A subsidiary argument was, in the alternative, that if Article 16 could not be construed in this way, then a term to similar effect should be implied into Article 16. Now, the first paragraph, I think, is articulated extremely well. The second one, maybe I wouldn't agree 100%, but the first one, yes. But there is a counter-argument. And also, there was a very famous, well-known expert witness working for Indian Overseas Bank. And if you search on Google, you will find this in the public domain. And the argument was, if the only obligation under the rules was to give a notice, okay? Notice that they didn't really have to follow up on what they said on the notice, but you know, that's a long stretch of an argument in any practical trade finance practitioner's view, in my mind. Any obligation to return the documents was outside the scope of the UCP, but you know, it was expressly stated return in the notice of refusal. And the argument went on, if contrary to its primary contention, there was an obligation to return the documents, well, then the obligation arose under the implied terms of the letter of credit and not under UCP. For me as a student, a practitioner, and Thomas, not an expert, well, if you say you're going to do it, you should do it, okay? And you should be held accountable. So, there was agreement between both sides, the expert evidence, that it is normal and expected international practice for banking practice for documents to be returned and disposal instructions to be complied with. So if you say it, if you talk the talk, well then really you're expected to walk the walk. Contrary to this, the issuing bank submitted that there is no express reference in UCP that issuing bank has an obligation to act in accordance with the choice it had elected. Also, there were no words in sub-article 16F, fascinating, which expressly provided for the sanction of preclusion. That there was no words in the rules that said if you don't follow what you say, you should be precluded, which actually is true. And of course, the court must make a decision, and the court must make a judgment that it deems fair, it deems equitable, but is actually consistent with the rules of practice and international standard banking practice in trade finance and letters of credit. So we're turning pages on the book. So what was the final conclusion? The final conclusion of the court concluded issuing bank was obliged to return the documents promptly when it said return. And then the issuing bank was therefore in breach of its obligation. And again, preclusion would apply, and the issuing bank was in a position that it should have to pay. So we can actually see that Article 16 procedure is really, really important. A letter of credit is obligation to pay if the documents comply, but even if they don't comply, provided they're presented within the expiry date, if you do not handle the the notice of refusal correctly, you may find yourself in the uncomfortable position of being precluded and having to pay. And this happens a lot more often than people are aware. And also for a beneficiary, and we have some exporters online here today, remember that this rule also applies to the confirming bank when you present your documents.
Okay, Vin, just one question from Ms. Ha in Ho Chi Minh City in Vietnam. She's asking if the issuing bank refuses correctly, but the dominated bank has already paid as LC had TT reimbursement, what can the issuing bank do?
Hi, Ms. Ha. Long time no see. I haven't been in Ho Chi Minh in a while, but nice to hear from you. And yeah, Thomas, I've got this. I've got the question. Okay, so I'll just repeat it, but maybe shorten it a little bit. Okay. Nominated or confirming bank has paid out the money because there was either a reimbursement authorization or, as you say, TT reimbursement before issuing bank got the documents. So the money is gone. The beneficiary has the money, right? And quite possibly that beneficiary, if this was a confirmed credit, may have that money, has the money without recourse. So he has the money. But if I got the question correct, now the issuing bank is checking the documents. They deem the documents discrepant. They've determined the discrepancies, okay? They issued their notice of refusal before the close of the 5th banking day, stating each discrepancy. But the money's gone. So I think the question was, what can the issuing bank do? Well, what you can do is know the rules. And under the rules, Article 16G, G for goods, good, states that if the issuing bank has refused the documents correctly, then that issuing bank is entitled to refund with interest. Refund with interest in respect of the payment that has been made. But of course, we're into step 2 now. There probably is going to be an argument between the issuing bank and the nominated bank. Documents comply, do not comply. But to answer your question, if the documents do not comply under the rules, the issuing bank is entitled, under the rules, expressly 16G, issuing bank is entitled to a refund with interest. So that's what you can do, okay? Yeah, and if you don't get your money, remember UCP. You can pray. Or remember UCP. You call, no, I'm joking. If there is a problem, of course, this is where the ICC can be very helpful, providing an official banking commission opinion. Or if that will not work for you, well, then, of course, you can go for a DocDex decision, okay? So that basically covers the notice of refusal, Article 16, the application of the preclusion rule, and then of course we went through quite a famous court case, Fortis versus Indian Overseas Bank, to actually illustrate the importance of the notice of refusal. So that basically covers it, Thomas. And
Okay.
I said I will be 30 minutes, but I'm actually about nearly 40. And
yeah, we have one more question actually in from Moldova, where I'll be going next week.
Okay.
Daniela from Chisinau in Moldova, and she's asking, interesting presentation, Mr. Vin, but the court decision, as you presented in Fortis versus Indian Overseas Bank, appeared very strict. Do you agree it was strict, and if so, what is the key lesson to be learned from the case?
Okay. First of all, do I think it was strict? I think it was strict, but I think that's the only way that the court can deal with this type of case, because we need very clear rules, very clear procedures, and banks must be aware of this rule. And that's actually one of the reasons that we're actually focusing on this topic, because banks get caught, okay, by not understanding the importance of Article 16 and the notice of refusal. So yes, I think it was strict, but do I think it was fair? I think it was fair. I think it was the correct application of the rules. And the last part was
basically, what can we learn from the case?
Oh, well, what can be learned from the case is that we need to all be aware of the rules. We need to apply the rules correctly, and we need to be aware of the dangerous consequences of not applying the rules, particularly in the context of Article 16 and the preclusion rule in UCP 600. UCP 600, the preclusion rule, which states if the bank does not follow Article 16, it may be precluded, which means even if the documents complied, the bank may have to pay.
Okay, fantastic. Okay, so Vincent, again, thanks so much for your time today. If we have any final questions from participants, I think you should speak now, or if you want, you can pass them to Vincent directly by email. We can provide his contact details later. But we'll just see if we have one final shake of the tree of any questions.
Actually, there's one here, Thomas, came in on my Skype. It's an interesting one. It's actually, am I sure that the preclusion rule does not apply to the nominated bank? That's a really good question, It's a really good question, and the only way to actually understand it is actually to read the rule, okay? Is to read the rule. And it's actually, I'm going to read it out, just so you know, I'm not joking, and that is Article 16F. If an issuing bank, and I'm reading it, it's not from memory this time, last time was from memory. 16F, if an issuing bank or confirming bank fails to act in accordance with the provisions of this article, close of the 5th banking day, single notice of refusal, stating each discrepancy, the disposal of documents as I articulated, well then the rule says, I'm reading it, it shall be precluded, stopped from claiming that the documents do not constitute a complying presentation. But that rule is articulated in the context of a confirming bank and issuing bank, okay, as opposed to Article 14 dealing with the examination by nominated bank, acting on its nomination, issuing bank, and confirming bank. So thank you.
Okay, Vincent, we have one question from Domenico Del Sorbo. He's asking, what is RMA? If that makes sense to you? Relationship Management Authorization.
Yeah, but it's basically the evolution. I'm no expert in SWIFT, but it's kind of evolution from the BKE, the authentication between, let's say, the banks using SWIFT. Yeah, but good point. Good.
Thanks, Elena, for the clarification there. Okay, great. So if everybody is happy, let me see now. We have Richard now. Okay, now he's just clarifying as well, meaning you can send authenticated SWIFT to another bank.
Great. Thank you for the help on that. I really appreciate it.
Okay, so if no other questions.
Just to highlight that, Thomas, what's coming up next, because we are responding to what people want to hear about. And what we've got requests, I don't know which one we're doing next, but you can tell me, Thomas. Trade finance fraud, in particular relation to letters of credit.
Yeah.
Okay.
Yeah.
And the other thing that keeps coming up is transferable and back-to-back letters of credit. So I'm not sure which we'll do first, but transferable, back-to-back, and of course fraud cases in letters of credit. And I have been involved as a witness in a number of cases. Actually, most of them never came to court, but there was allegations of fraud. So I have a good insight into the key aspects. So I think that would be an interesting topic. Maybe the next one we'll do, Tom. What do you think?
That's fantastic. That sounds great.
Okay.
Really, really good.
Good.
Okay, so Vincent, thanks so much for your time today.
And thank you. And especially I want to thank Thomas for the web deployment and all his assistance. He goes through a lot of work. And my colleague Nezarul from Bangladesh, who always gives me great assistance, technical assistance regarding all of this work that we're all working together in. So thank you guys, and thanks very much. I'll sign off.
From Domenico Del Sorbo, he has said, I would like to thank Vincent for his interesting presentation. Thanks again, Domenico, for your feedback. It's much appreciated. Okay, so and Valentina as well, we have coming in on Skype. She's saying thank you. And,
okay.
We're getting a couple of messages in on Skype on various ones here now, Vincent.
Yeah, no problem. Okay.
Great.
Okay, Valentina, see you soon. Okay.
Okay,
Bye.
so we'll call it a day for today. Thanks everybody for taking part.